Hello class, before we begin, let us start with a prayer. Psalm 23. The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside still waters. He restores my soul. He leads me in paths of righteousness for his name's sake. Even though I walk through the valley of the shadow of death, I will fear no evil, for you are with me. Your rod and your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil. My cup overflows. Surely, goodness and mercy shall follow me all the days of my life, and I shall dwell in the house of the Lord forever. Amen. So, greetings class. Our topic for today is all about criminal law. So, this is a continuation of our previous topic, criminal law 1. So, for today, we will discuss all about the book 2 of the revised penal code. Okay? So, I would like to state for the record that I am using the reviewer from UP College of Law. Okay? So, I do not own this reviewer. I'm only using this for purposes of discussion because this reviewer is an overview of our topic today. So, for the record, all credits goes to UP. So, thank you UP. So, without further ado, let us begin. Book 2 of the revised penal code. Okay? So, under Book 2 class of the revised penal code, all crimes are enumerated. Okay? They are segregated in titles. So, title number 1 is Crimes Against National Security and the Law of Nations. Okay? So, under this crime, under title 1, so crimes against security, Article 114 is treason. Next, Article 115, conspiracy and proposal to commit treason. Okay? And then 116, misprision of treason. And then 117, espionage. And then, under crimes against the law of nations, so there is inciting to war or giving motives for reprisals. Next, violation of neutrality. Next, correspondence with hostile country. Next crime is flight to enemy's country. Next is piracy in general and mutiny on the high seas or in the Philippine waters. And then lastly is qualified piracy. Okay? So the crimes under this title can be prosecuted even if the criminal act or acts were committed outside the Philippine territorial jurisdiction. Okay, so we have learned in criminal law 1 that Philippine criminal law is jurisdictional in character. Okay, so when you say jurisdictional, if you commit a certain crime in that location, then you can only be prosecuted in that jurisdiction also. Okay. However, crimes involving national security and the law of nations, so even though the perpetrator is located outside the country, then he can still be prosecuted. Okay? Because this involves national security. So this is one of the instances where the revised penal code may be given extraterritorial application. Okay? So when you say extraterritorial application, it means that the prosecuting arm of the law can still reach the perpetrator even though that person is outside its jurisdiction. Okay? So, under Article 2, paragraph 5 thereof. However, prosecution can proceed only if the offender is within the Philippine territory or brought to the Philippines pursuant to an extradition treaty. Okay? So, the person class violating the said offense can be held liable. However, that person can only be prosecuted. Okay? So, when you say prosecution or prosecuted, it means that you can only file a case in court if the person, okay, is brought to the Philippine territory, okay, or if the person is within the Philippine territory. Next, crimes against national security can be tried only in the Philippines. So, okay, so like what I said earlier, the person must be brought inside the jurisdiction of the Philippines for that person to be prosecuted. However, if the person has committed a crime even outside, then he can be liable. Okay? But the procedure, in the procedural aspect, you can only prosecute the perpetrator if he is brought to the Philippines. Okay? So, in the case of crimes against the law of nations, the offender can be prosecuted whenever he may be found because the crimes are regarded as committed against humanity in general. In the other hand class, crimes against the law of nations class, the perpetrator can be prosecuted anywhere because these crimes like piracy, okay, these are considered a crime against humanity. Okay? That is why if the perpetrator committed the crime, then he can be prosecuted at any jurisdictions or at any nations. So the acts against national security may be committed abroad and still be punished under our law. Okay? So that person can be prosecuted on the country where he committed a crime, or he can be prosecuted in the Philippines. Okay? Because these crimes, the crimes against the law of nations, are considered to be crimes against humanity. So as a general rule, all of these are crimes committed in times of war. Okay? However, there are exceptions. So first, in case of espionage or under Article 117, so this is also covered by Commonwealth Act number 616, which punishes conspiracy to commit espionage. Okay? Next, inciting to war or giving motives for reprisal. Okay? If the perpetrator instigates war or gives reason for reprisals or getting back at the victim. So this can be committed even if the Philippines is not a participant. Next, violation of neutrality. So the Philippines is not a party to an ongoing war. Okay, so these are the exceptions class. Now, let's discuss treason. Okay, so under crimes against security, first is treason. So there are modes of commission of this crime. So mode number 1 is first levying war. Okay, so the perpetrator levies war. So the elements are the offender is a Filipino or a resident alien. Okay, so you determine the nationality of the perpetrator. Next, there is a war in which the Philippines is involved. And then next, the offender levies war against the government. Okay? So, that's the first mode of committing treason. The second mode is adherence to the enemy and giving of aid or comfort. Okay? So, the phrase itself is self-explanatory. The second mode is when you support the enemy of the state. Okay? So, these are the elements, class. These are matters of reading. Okay? So, we will just make a rundown of book 2 of the revised penal code, class, because this topic is very broad, very long. Okay? So, some items or provisions are just matters of reading. Okay? We will just make a rundown. So, these are the elements, class. These are just matters of reading. Okay? So, treason is a breach of allegiance to a government. Okay? So, if you are a citizen and then you broke your allegiance to the state, then you commit treason. Okay? It is committed by a person who owes allegiance to it. It cannot be committed in the time of peace. Okay? So, one element which is important in this crime is that it must be committed at the time of war. So, there are two ways of committing treason. First, like what we discussed earlier, mode 1, the perpetrator levies war against the government. And then next, the mode 2, the perpetrator adheres to the enemy and then gives them aid or comfort. Okay? So, to be treasonous, the extent of aid and comfort given to the enemies must be to render assistance to them as enemies and not as individuals. Okay? So, you support them. You support their cause. Okay? So, in the furtherance of the enemy's hostile designs. Okay? Next is intent of disloyalty is a vital ingredient in the crime of treason. Okay, remember in book 1, we have discussed that in the revised penal code, intent is necessary. Okay, there must be intent to kill for murder, intent to gain for theft or robbery. In this case, there is intent of disloyalty as a ingredient of the crime of treason, which in the absence of admission may be gathered from the nature and circumstances of each particular case. So now it becomes factual in character. Okay, it is now a matter of evidence. So we have discussed this. Mode number 1 in committing treason is the perpetrator levies war. Okay, so these are the elements. These are just matters of reading, class. Okay? And then mode number 2 is adherence to the enemy. Okay? Giving them aid or comfort. So this means that the enemy must concur. Okay? So there is like a conspiracy between the perpetrator and the enemies of war. So adherence to the enemy means intent to betray. Okay, so there is intent to betray the government. Aid or comfort means an act which strengthens or tends to strengthen the enemy in the conduct of war against the traitor's country, and an act which weakens or tends to weaken the power of the traitor's country to resist or to attack the enemy. Okay? So, these are discussion, class. These are cases. By the way, class, I will also give cases, okay, actual Supreme Court cases that you will digest, okay, and then make a reaction paper after. Now, let's define enemies. So, the term enemies applies only to the subjects of a foreign power in a state of hostility with the traitor's country. Okay, so when you say enemy, so these are the persons in another country who are engaged in war with our country. Okay? So the overt act, aid, and comfort to the enemy must be intentional. So once again, intent is an ingredient of this crime. because it is under the revised penal code, as distinguished from merely negligent or undesigned ones. So when the killing and other common crimes are charged as overt acts of treason, they cannot be regarded as a separate crime or as a complex crime with treason. Okay? So, if a crime of treason is committed, class, and then incidentally there is death or there is looting, so it absorbs those crime. Okay? However, there is an exception. But this rule would not preclude the punishment of murder or other common crimes as such if the prosecution should elect to prosecute the culprit specifically of these crimes instead of relying on them as an element of treason. Okay? So the exception is if the prosecutor, okay, will choose to prosecute the crime itself, like if that person committed murder, okay? So the prosecutor will prosecute the perpetrator for murder. Okay? So that's the exception. However, if the prosecution would only prosecute the crime of treason, and then the death would be placed as an incidental event, then the crime committed is only treason. Okay? So it's up to the prosecutor, class, on what crime he or she will prosecute. So treason by a Filipino citizen can be committed outside of the Philippines. So treason by an alien must be committed within the Philippines. Okay? So the nationality plays a vital role in the commission of treason. Okay? So these are just matters of reading, class. So two ways of proving treason. First, there must be a testimony of at least two witnesses to the same overt act. Okay? So the overt act of treason, there must be at least two eyewitnesses. And then second, confession of the accused in open court. Okay? So under the law, under the criminal law, there is what we call the two-witness rule in proving treason. So the testimony of two witnesses is required to prove the overt act of giving aid or comfort. Okay, so this is the second mode in the commission of treason. So it is not necessary to prove adherence. So each of the witness must testify to the whole overt act, or if it is separable, there must be two witnesses to each part of the overt act. Okay? Now, how to prove adherence to the enemy? So, first, there must be an eyewitness. Okay? One is sufficient. And then from the nature of the act itself, or for the circumstances surrounding the act. Okay? So, it becomes a matter of evidence, class. Because in proving, it must be factual in nature. Okay? So, if you commit treason and there are circumstance which aggravates the crime, okay? So, the penalty will be increased. So, what are the circumstances that aggravates the crime of treason? One is cruelty and ignominy are considered aggravating circumstances in treason. Okay? So, these are case doctrines, class. We will not discuss this because you will be given cases after our lecture. Okay? Okay. Now, let's go to defense of suspended allegiance and change of sovereignty are not accepted. Okay? Because, so, if you are the one who commits treason, if you are the one being prosecuted, you cannot make it your defense that there was a suspended allegiance or a change of sovereignty. Okay? Because the elements of treason is specific and clear. Okay? Even though our sovereignty, so for example, the Philippines, we were defeated by a foreign country. And by virtue of our defeat, there is a change of sovereignty. Okay? Okay? We now become a country also. Part of the country of the winning country of after the war. So, when Filipinos will regain the country, the Philippines, back to the versus our opponent, and then the perpetrator will be prosecuted, okay? So he cannot use the defense that there is a change of allegiance or a change of sovereignty. Okay, he can still be held liable even if there are change in sovereignty. Okay, so these are just matters of reading, class. Okay, now let's go to another crime: conspiracy and proposal to commit treason. Okay. So, what are the elements of conspiracy to commit treason? First, there is a war in which the Philippines is involved. Second, at least 2 persons come to agreement to levy war against the government or adhere to the enemies, giving them aid or comfort. Okay? So, there is conspiracy, class. So, that person proposes its execution to other persons and then they decide to commit it. Okay? So there is meeting of minds in order to commit treason. Okay? Next is proposal to commit treason. Elements: there is a war in which the Philippines is involved, and then at least 1 person decides to levy war against the government or adhere to the enemies, giving them aid or comfort. Okay? So what is essential here, class, is that there is a meeting of minds between the perpetrators. Okay? There is conspiracy. So as a general rule, conspiracy and proposal to commit a felony is not punishable under Article 8. However, there is an exception. So the exception is under Article 115. Mere conspiracy or proposal to commit treason is punishable because of the reason that these are crimes involving national security. Okay? The security of our nation is at stake. That is why proposal to commit treason is punishable under the law. This is also because in treason, the very existence of the state is endangered. Okay? Next is misprision of treason. Elements are offender owes allegiance to the government and is not a foreigner. Okay? Next, he has knowledge of conspiracy to commit treason against the government, and then he conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province in which he resides or the mayor or fiscal of the city in which he resides. So in case of misprision of treason, class, you have personal knowledge that there is treason going on. Okay? There is conspiracy. However, you did not disclose to the government. Instead, you concealed it. Okay? So even though you are not part of the crime, you can still be prosecuted under this article. Okay? Misprision of treason. Failure for you to tell the government of the plan of treason. Okay? So misprision of treason is a crime that may be committed only by the citizens of the Philippines. So one important ingredient, class, is that the perpetrator must be a citizen of the Philippines. It cannot be committed by a resident alien. Okay? So the essence of the crime is that there are persons who conspired to commit treason and the offender knew this and failed to make the necessary report to the government within the earliest possible time. Okay? So, failure to report personal knowledge of treason, then you can be prosecuted provided that you are a citizen of the Philippines. You can be prosecuted under misprision of treason. Okay? So, these are just matters of reading, class. Okay? Now, let's go to another article, espionage. So, once again, there are different modes in committing this crime of espionage. Mode number 1 is first, entering of establishment to obtain confidential information regarding defense of the Philippines. Okay? For example, you enter the office of the Department of Defense, okay, in order to gain confidential information with regards to our defense of our state, okay. There are elements in the commission of this crime. First, that the offender enters a warship, a fort, or naval or military establishment or reservation, okay, like military barracks, and other government offices protecting the integrity of our national security. Next element, that he has no authority to enter, okay, or to be there at that place. Next, that his purpose is to obtain information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippines, okay? So, when you say espionage, class, you are obtaining sensitive data with regards to the defense of the Philippines. So, that's the first mode of committing espionage, when you enter said establishment with the intent to obtain confidential information. The next mode in the commission of this crime is disclosing by public officer of confidential information to a foreign representative. Okay? So, classic example, if you for example, you disclose sensitive information with regards to our national security to the CIA, okay, and other foreign bodies or representative. So, the elements are that the offender is a public officer, okay? You are a public officer. And then second, that he has in his possession the articles, data, or information of a confidential nature relative to the defense of the Philippines by reason of the public office he holds. Okay? So, in this mode, class, the perpetrator must be a public officer. And as a public officer, he has in his possession, by reason of his office, sensitive information with regards to our defenses. Okay? So, this is the second mode in the commission of espionage. Okay? So, he discloses the contents to a representative of a foreign nation. So, under paragraph 1 of Article 117, the offender is any person, whether a citizen or a foreigner. Okay? So, it is immaterial if your nationality is not a Filipino, because what is sanctioned, class, is the entering of the establishment, okay, where sensitive information of our defenses can be found. Under paragraph 2, the offender must be a public officer who has in his possession the information by reason of public office he holds. Okay? So, these are just matters of reading, class. Now, let's differentiate espionage and treason. So, under espionage, class, espionage is not conditioned by the citizenship of the offender. So, nationality is immaterial. Okay? However, in case of treason, it is not conditioned by the citizenship of the offender. So they are the same. Okay? Citizenship is immaterial. Next, under espionage may be committed both in time of war and in time of peace. Okay? Of course, you enter into establishment and then you obtain vital or sensitive information. So it can be done in time of peace. On the other hand, in treason, it can only be committed only in time of war. Okay? So under espionage may be committed in many ways. Okay, there are modes. In the other hand, under treason, limited only to two ways of committing the crime. First is levying of war, and then adhering to the enemy, giving them aid and or comfort. Okay? So those are the crimes against national security class. Now let's go to crimes against the law of nations. So when you say crimes against the law of nations, these are considered crimes against humanity. Okay? So these acts, okay, can be prosecuted anywhere in the globe. So Article 118, or inciting to war or giving motives for reprisals. The elements are the following. Offender performs an unlawful or unauthorized act. Next, the act provoke or give occasion for a war involving or liable to involve the Philippines, or exposure of Filipino citizen to reprisals on their persons or property. Okay? So, this person's class instigates war, or they instigate other persons that would place in danger Filipino citizens for reprisal. When you say reprisal, kanang bawsan ba? Binisaya na, bawsan. Okay? Against their person and their property. So, this crime is committed in time of peace. Okay? So, the intention of the offender is immaterial. So, in this case class, intent is immaterial because this crime can be prosecuted anywhere. Okay, so these are crimes committed against humanity. Okay, so intent is not an important ingredient of this crime. So the law considers the effect produced by the acts of the accused. Okay, example, the raising without sufficient authorization of troops within the Philippines for the service of a foreign nation against another nation. Okay? For example, there is a warlord and then he has private armies. Okay? He trains troops in order for them to serve to foreign nations. Classic example, maybe the Mauti group. Okay? Because they think that they are part of ISIS. Okay? Now, let's go to the next article, violation of neutrality. So, the elements are, there is a war in which the Philippines is not involved. Then, there is a regulation issued by a competent authority to enforce neutrality. And then, the third element is that the perpetrator or offender violated such regulation. Okay? So, Philippines is not part of the war. And then, example, United Nations has a regulation that Philippines should be neutral. It should not involve in the war. However, the offender or the violator or the perpetrator violated said regulation that would put us in danger. Okay? So, what is the definition of neutrality? A nation or power which takes no part in a contest of arms going on between other countries. So, when you say neutrality class, we are not involved. Okay? We are in the middle. We are neutral. Okay? Now, let's go to another article, correspondence with hostile country. So, the elements are the following. It is in the time of war in which the Philippines is involved. Next, offender makes correspondence with an enemy country or territory occupied by enemy troops. So when you say correspondence, you communicate with the enemy, okay, in times of war. And then the correspondence is either prohibited by the government, okay, or carried on ciphers or conventional signs, or containing notice or information which might be useful to the enemy. Okay, so these are the requirements, class. You communicate sensitive information to the enemy in time of war. So you can be held liable for violation of correspondence with the hostile country. Okay? So, under the law, correspondence is defined as communication by means of letters which pass between those who have friendly or business relations. Okay? So, correspondence in layman's term is communication. Okay, these are just matters of reading. Next article, flight to enemy's country. So, the elements are the following. There is a war in which the Philippines is involved, and then offender must be owing allegiance to the government, and then offender attempts to flee or go to enemy country. And then lastly, going to the enemy country is prohibited by our competent authority. So, flight to enemy's country, class, is that the idea is that the Philippines is at war with another country. And then the perpetrator has allegiance to the government. However, perpetrator attempts to flee or go to the enemy country, and then there is a regulation or law prohibiting said act. Okay? So you can be held liable under this article. So, an alien resident may be guilty of flight to enemy country. The law does not say not being a foreigner. Hence, the allegiance contemplated in this article is either natural or temporary allegiance. Okay? So, mere attempt to flee or go to the enemy country consummates the crime. Next is piracy in general and mutiny on the high seas or in Philippine waters. So, piracy, class, is once again considered a crime against humanity. Okay? So, the elements are the following. The vessel is on the high seas or in the Philippine waters. Next, offenders are neither members of its complement nor passengers of the vessels. Okay, so they are not passengers nor members of the crew. Next, offender either attack or seize that vessel or seize the whole or part of its cargo, its equipment, or personal belonging of its complement or passengers. And then the last element, there is intent to gain. Okay, so these are very common in high seas class where piracy is rampant. Okay, pirates. So the acts being punished in piracy is the attacking or seizing a vessel on the high seas or in Philippine waters. So seizing the whole or part of its cargo, complement, or passengers while the vessel is in the high seas or in the Philippine waters. Okay? So, what does high seas means, class? So, the Convention on the Law of the Sea or UNCLOS defined it as part of the seas that are not included in the exclusive economic zone. Okay? It is beyond our EEC. In the territorial seas or in the internal waters of a state or in the archipelagic waters of an archipelagic state. Okay? What does piracy means? So it is robbery or forcible depredation on the high seas without lawful authority and done with animo furandi and in the spirit and intention of universal hostility. Okay? So, in other words, class, piracy class is like robbery in the high seas. Okay? Now, what is mutiny? So, it is the unlawful resistance to a superior officer or the raising of commotion and disturbance. So, when you say mutiny class, the violators or the perpetrators are the members of the said vessel. So, mutiny is punished in Article 122. Mutiny is usually committed by the other members of the complement and may be committed by the passengers of the vessel. Okay? So, in piracy class, persons who attack the vessel or seize its cargo are strangers. Okay? They do not belong to the vessel, its crew, or its passenger. In the other hand, mutiny, they can be members of the vessel or the crew or its passengers. Okay? So, these are just matters of reading, class. Okay? Article 123, qualified piracy. So, what are the elements? The vessel is on the high seas or Philippine waters. And then, offenders may or may not be members of its complement and or passengers of the vessel. And then, offenders either attack or seize the vessel or seize the whole or part of its cargo, its equipment, or personal belonging of its crew or passengers. The preceding were committed under any of the following circumstance. Okay? So, whenever they have seized a vessel by boarding or firing upon the same, okay, they used firearms or weapons. Next, whenever the pirates have abandoned their victims without means of saving themselves, okay, so they left the passengers or the crew without any means to save themselves, okay, they removed the fuel, okay, they destroyed the engine of the boat in the high seas, okay. Next, whenever the crime is accompanied by murder, homicide, physical injuries, or rape, okay. So, if these crimes are committed, then the perpetrators or violators can be held liable under piracy, okay. So, these are just matters of reading, class, okay. So, there is a special law, the PD 532 or the Anti-Piracy and Anti-Highway Robbery. So, we will not discuss this. We will discuss this at another time. Okay. Another special law, RA 6235 or the Anti-Hijacking Law. Another special law, RA 9372 or the Human Security Act of 2007, which discusses terrorism. Okay, so these are special penal laws that we will discuss later on, class. Okay, in this discussion, class, in this topic, we will focus only on the crimes committed under the Revised Penal Code, Book 2. Okay. Next title, class of Book 2 of the Revised Penal Code are crimes against fundamental laws of the state. Okay, so when you say fundamental laws of this of the state, it means that these are crimes against the Constitution, the Bill of Rights, okay, and so on and so forth. Okay. Because the Constitution is the fundamental law of the land. So, under this title, there is Article 124 or arbitrary detention. And next is delay in the delivery of detained persons to the proper judicial authorities. Next, delaying release. Next, expulsion. Next, violation of domicile. Next, search warrants maliciously obtained and abused in the service of those legally obtained. Next, searching domicile without witnesses. Next, prohibition, interruption, and dissolution of peaceful meeting. Next, interruption of religious worship. And then lastly, offending the religious feelings. Okay? So, these crimes class are common in your profession. Okay? Because as law enforcers, as public officers, you must uphold the Constitution. Okay? The fundamental rights of the citizens. The Constitution class, especially the Bill of Rights, guarantees the rights of the citizens or any sojourning in our country. Okay? So, crimes under this title are those that violate certain provisions of the Bill of Rights. So, all offenses under this title can only be committed by public officers except offending the religious feelings. Okay? Very common in your profession class. So, the primary offender in Articles 124 to 132 is a public officer acting under the supposed exercise of official functions. Okay? A private person may be liable under this article only when the private person conspires with the public officer or he becomes an accomplice or accessory to said crimes. Okay? Article 133 can be committed by either a public officer or a private individual. Now, let's start arbitrary detention. So, what are the elements? That the offender is a public officer or employee. That he detains a person. And that the detention is without legal ground. Okay? So, the person, okay, the victim, is detained illegally. Okay? There is no ground for it, for his or her detention. And another element, you are a public officer, a law enforcer. Okay? So, these are the ingredients in the commission of this crime. Okay? So, the crime of arbitrary detention assumes several forms. First is detaining a person without legal ground. Next, having arrested the offended party for legal grounds but without warrant of arrest, and the public officer does not deliver the arrested person to the proper judicial authority within the period of 12, 18, or 36 hours, depending on the penalty class, as the case may be, or delaying release by competent authority with the same period mentioned in Article 2. Okay? So, the detention of a person is without legal ground. So, when he has not committed any crime, or at least there is no reasonable ground for suspicion that he has committed a crime, or when he is not suffering from violent insanity or any other ailment requiring compulsory confinement in a hospital. So, a public officer is deemed such when he is acting within the bounds of his official authority or functions. Okay? So, a police officer who employs force in excess of what is necessary is acting outside the bounds of his duties and is considered acting in his private capacity. Okay? So, bear that in mind, class. So, if you use force which is in excess of what is necessary, then it is deemed that you have committed such act in your private capacity. So, in crimes of arbitrary detention, although the offender is a public officer, not any public officer can commit this crime. Okay? So, not all public officer can commit the crime of, can commit this violation. Only those public officer whose official duties carries with it the authority to make an arrest and detain a person. Okay? So, more often than not, these are law enforcers such as yourselves, class. Okay? So, these are jurisprudence, class. These are just matters of reading. Okay? Now, let's go to the difference between arbitrary detention, illegal detention, and unlawful arrest. So, the offender. In arbitrary detention, offender is a public officer who has the authority to make arrest and detain persons. On the other hand, illegal detention, the perpetrator or offender can be private person or public officer who is acting in a private capacity or beyond the scope of his official duty. Unlawful arrest, on the other hand, the offender is any person, okay, private or public. Criminal intent, okay, under arbitrary detention, violate the offended party's constitutional freedom, okay. Under illegal detention, deprive the offended party of his personal liberty. So, this must be differentiated, class, because under arbitrary detention, what is violated is the constitutional right of the victim. Okay? On the other hand, because in illegal detention, because this can be done by private individuals, then what is violated is the deprivation of the personal liberty of the victim. Okay? In unlawful arrest, accuse the offended party of a crime he did not commit, deliver him to the proper authority, and file the necessary charges to incriminate him. Okay? Now, let's go to another article, delay in the delivery of detained persons to the proper judicial authorities. So, the elements are the following. Offender is a public officer or employee, and then he detains a person for some legal ground, and then he fails to deliver such person to the proper judicial authorities within 12 hours for light penalties, 18 hours for correctional penalties, and then 36 hours for afflictive or capital penalties. So there is a time frame in order to deliver detained persons to the judicial authority. So this is applicable only when the arrest is without warrant, but the arrest must be a lawful one. Okay? So at the beginning, the detention is legal since it is in pursuance of a lawful arrest. However, detention becomes arbitrary when there is already lapse of the period without arresting officer filing a formal charge with the proper court. So the periods stated are counted only when the prosecutor's office is ready to receive the complaint or information. Nighttime is not included in the period. Okay? So, what does delivery means? It means the filing of correct information with the proper court, or constructive delivery, turning over the person arrested to the jurisdiction of the court. So the purpose is to determine whether the offense is bailable or not. Okay? So what is essential, class? So even if the person is detained for more than the period, okay, prescribed by law, for example, you detain the person on Friday, and then of course there's no office in Saturday and Sunday. So what is important that you file you bring him to the prosecutor's office at the earliest possible opportunity in Monday, so that you will not be held liable under this provision of law. Okay? So these are just matters of reading, class. One important aspect that you need to consider is detained person should be released when a judge is not available. On the other hand, if the person detained signs a waiver, then the public officer, of course, will not be held liable. So, waiver of the provision of Article 125. Before the complainant or information is filed, the person arrested may ask for a preliminary investigation in accordance with Rule 112 of the Revised Rules of Criminal Procedure. But he must sign a waiver of the provisions of Article 125 of the Revised Penal Code in the presence of his counsel. Notwithstanding the waiver, he may apply for bail and the investigation must be terminated within 15 days from its inception. Okay. Next article, delaying release. So the elements are the following. Offender is a public officer or employee. Okay. Then there is a judicial or executive order for the release of a prisoner or detention prisoner, or a proceeding upon a petition for liberation of such person. What is essential, class, is that there is already an order for release, okay, and the offender did not comply. Another element is offender without good reason delays the release. So the service of notice of such order to the prisoner, the performance of such judicial or executive order for the release of the person, or the proceeding upon a petition for release of such person. So this petition is the writ of habeas corpus. Okay. Next provision, next article is expulsion. So the elements are the following. Offender is a public officer or employee, and then he either expels any person from the Philippines or compels a person to change residence, or offender is not authorized to do so by law. Okay? So this is very common, class. Expulsion. There is threat in security of the person. Okay? That's why he or she is forced to change resident. Very common in politics. For example, you are running for mayor. Your opponent is very influential. Say, a warlord. Okay? You are defeated. Of course, your opponent becomes the mayor. And because he is already the mayor and he has influence over the resources and the employees of the city or the municipality, then there is threat in your life. So if you will not leave, for example, he will say, if you will not leave, it's either you will die or you will be imprisoned or something like that, because your opponent is afraid that you will run again. Okay, so that person is vindictive. So that is common in Philippine politics also. Okay, that is why more often than not, persons or individuals who are defeated on elections, they tend to go to the United States or go to other places, okay? And they will come back next election to the place where they want to be elected. So, in the case of Villavicencio versus Lucban, the city mayor of Manila committed the crime of expulsion when he ordered certain prostitutes to be transferred to Davao without observing due process, since they have not been charged with any crime. Okay? So one important element is that you are a public officer and that you committed uh, the either you committed any of the three mentioned circumstance. Okay? So these are just matters of reading, class. Next article is violation of domicile. So, acts punishable, entering any dwelling against the will of the owner thereof. Okay, so you illegally enter the dwelling of a person without his consent, or searching paper or other effects found therein without previous consent of such owner, or refusing to leave the premises after having surreptitiously entered said dwelling and after having been required to leave the same. Okay, so these are just self-explanatory provisions, class. Okay, these are just matters of reading. I will leave this up to you. Okay, matters of reading. Next article, search warrants maliciously obtained and abused in the service of those legally obtained. So the elements are the following. So, elements of procuring a search warrant without just cause. First, the offender is a public officer or employee. Then he procures a search warrant, and then there is no just cause or legal purpose. So you can be held liable. And then elements of exceeding authority or using unnecessary severity in executing a search warrant legally procured. So another mode is that there is a valid search warrant. However, there is an excess of force or the performance of such authority given is unnecessary or severe. Okay? So the elements are the following. Offender is a public officer or employee. Then he has legally procured a search warrant. And then he exceeds his authority or uses unnecessary severity in executing the same. Okay? For example, you kick the door, you destroy the property. Okay? Next article, searching domicile without witness. So this is a self-explanatory article, class. This is just a matter of reading. I will leave this up to you. Next article, prohibition, interruption, and dissolution of peaceful meeting. Okay? So, element again is the offender is a public officer or employee, and then he performs any of the following acts: prohibiting or interrupting without legal ground the holding of a peaceful meeting or by dissolving the same. Okay? So, the participants, you tend to what do you call this, dissolve their meeting or destroy their how they organized. So hindering any person from joining any lawful association or from attending any of its meeting. You prohibit a person to join. Okay? And then prohibiting or hindering any person from addressing either alone or together with others any petition to the authorities for the correction of abuses or redress of grievances. Okay? So these are just self-explanatory provisions, class. So the government has a right to require a permit before any gathering can be made. However, the government only has regulatory, not prohibitory powers with regard to such requirement. Okay? So the permit should state the date, time, and place of the gathering. Okay? So if you violate said meeting, then you can be held liable under this provision of law. Next, article, interruption of religious worship. Okay, these are just matters of reading, class. I will leave this up to you. Okay? And then, offending. Next article, offending the religious feelings. So the elements are the following. Acts complained of were performed in a place devoted to religious worship, or during the celebration of any religious ceremony. Okay, so you offended the religious practice. So the act must be notoriously offensive to the feelings of the faithful. Okay? So what is essential is that the place must be devoted to a religious worship. Okay? So these are just matters of reading, class. Another special law, Anti-Torture Act. We will discuss that. Okay. Wait. Wait, class. Okay, wait. Wait. Wait, class, wait. Wait. Okay. So where were we? So these are special laws, class. We will discuss this in another topic, the Anti-Torture Act. Okay, it's in these provisions. Now let's go to crimes against public order. So under this title, these are the following crimes: rebellion or insurrection, Codita, penalty for rebellion, insurrection, or Codita. Then conspiracy and proposal to commit Codita, rebellion, or insurrection, disloyalty of public officers or employees, inciting to rebellion or insurrection, sedition, conspiracy to commit sedition, inciting to sedition, okay, persons liable for sedition, and then acts tending to prevent the meeting of Congress of the Philippines and similar bodies, disturbance of proceeding, violation of the parliamentary immunity, illegal assemblies, illegal association, direct assault, and indirect assault. Okay? Next, violations, disobedience to summons issued by Congress in its committees or subcommittees, by the constitutional commissions, its committees and subcommittees or division, and then tumults and other disturbances of public order, resistance and disobedience to a person in authority or the agents of such persons, unlawful use of means of publication and unlawful utterances, delivering persons from jail, alarms and scandals, evasion of service of sentence, other cases of evasion of service of sentence, evasion of service of sentence on the occasion of disorders, conflagration, earthquake, and other calamities, and then lastly, quasi-recidivism. Okay? So, let's just make a rundown, class. Because some of these articles are just matters of reading and are self-explanatory. Now, first, let's go to Chapter 1, Rebellion, Codita, Sedition, and Disloyalty. So, under rebellion or insurrection, class, the following elements must concur. First, there is a public uprising and taking arms against the government. Okay? Public uprising. So, the purpose of the uprising or movement is to remove from the allegiance to the Philippine government or its laws or the Philippine territory, any part thereof, or any body of land, naval, or other armed forces. Okay? So the purpose of the taking up of arms class or the uprising is to dispossess or to remove allegiance to the government. Okay, dispossess the Philippines of its territory or any part thereof. Next is to deprive the chief executive or Congress, wholly or partially, of any of their powers or prerogative. Okay? So, rule on complexing of rebellion. So, rebellion cannot be complex with but absorbs other crimes committed in furtherance of rebellion. There is no complex crime of rebellion with murder and other common crimes. So, if there are crimes class, for example, like robbery, murder, okay, at the time of the commission of the rebellion, then it is considered to be part of that rebellion. So, when you prosecute, the crime committed is rebellion. Okay? So, the doctrine laid down in People versus Hernandez remains a good legal basis. So, this prohibits the complexing of rebellion with any other offense committed in occasion thereof, either as a means to its commission or as an unintended effect of an activity that constitutes rebellion. So, there is no complex crime of rebellion class, okay? So, there is only rebellion. So, in case there is murder or robbery due to rebellion, then those offenses are absorbed. Okay? So, these are matters of reading class. Now, let's differentiate rebellion and insurrection. So, the object of rebellion is to completely overthrow and supplant the existing government. Okay? Classic example, NPA. Okay? Insurrection, on the other hand, it is a movement seeking to effect some change of minor importance or to prevent the exercise of governmental authority with respect to a particular matters or subject. So, in insurrection class, it is not permanent in nature. Okay? The aim is to prohibit the government to exercise certain governmental authority. On the other hand, when you say rebellion, it has a character of permanency, okay, continuous, element of time is present, okay. However, on the other hand, insurrection is like limited, on the main aim is only to prohibit the exercise of a governmental authority with respect to a particular matter. Okay? So, rebellion and treason class, we have discussed this already. Subversion. So, when you say subversion, these are crimes against national security. Okay? So, being officers and ranking members of subversive group constitutes subversion. So, there is no longer a crime of subversion by virtue of RA 7636, which repealed RA 700. Okay, the subversion crime class is already abolished by virtue of that law. Okay. Next, let's go to Codita. So, what are the elements of Codita? So, offender is a person or persons belonging to the military or police or holding any public office or employment. Next, it is committed by means of a swift attack. Okay, that's an important element class. There is swift attack accompanied by violence, intimidation, threat, strategy, or stealth. And then the attack is directed against the duly constituted authorities of the Republic of the Philippines or any military camp or installation, communication networks, public utilities, or other facilities needed for the exercise and continued possession of power. Okay? Classic example is at the time of the presidency of Gloria Macapagal Arroyo, the Magdalo group under Trillanes, I think, committed Codita in order to overthrow the government. So the purpose of the attack is to seize or diminish state powers. Okay. So who are persons that can commit this crime? Codita. First, it may be committed singly or collectively. Okay. It can be committed by an individual or as a group. Then requires a principal offender, a member of the AFP, PNP, or a public officer with or without civilian support. Okay? So the crime of Codita may be committed with or without civilian participation. So is Codita considered terrorism? A person who commits an act of punishable as Codita under Article 134-A of the Revised Penal Code, including acts committed by private person, thereby sowing and creating a condition of widespread and extraordinary fear and panic among the populace in order to coerce the government to give in to an unlawful demand shall be guilty of the crime of terrorism also. Okay? Now, Article 135 is the penalty for rebellion, insurrection, and Codita. Okay, these are just matters of reading, class. I will leave this up to you. Article 136 is conspiracy and proposal to commit Codita, rebellion, or insurrection. Okay? So, matters of reading again. Next article, disloyalty of public officers or employees. So, the elements are the following. Offender is a public officer or employee. Then, offender commits any of the following acts. First, failing to resist a rebellion by all the means in their power. Next, continuing to discharge duties of their office under the control of the rebels. Then next, accepting appointment to the office under the rebels. Okay? So, they can be prosecuted for disloyalty. Okay? Next article is 138, inciting to rebellion or insurrection. So the elements are the following. Offender does not take arms or is not in open hostility against the government. And then he incites others to the execution of any of the acts of rebellion. And then the inciting is done by means of speeches, proclamation, writing, emblems, banners, or other representations tending to the same end. Okay, so when you say you incite, there is an element of support. Okay, you raise banners in furtherance of rebellion or insurrection. Okay, so these are just matters of reading, class. Now let's go to another article, sedition. So the elements of sedition are the following. Offenders rise publicly and tumultuously. Okay, so there is public uprising again in a tumultuous manner. So when you say tumultuous, nagkagubot. In layman's term, nagkagubot. Okay. Offenders employ force, intimidation, or other means outside of the legal methods. Okay? So, the purpose is to attain any of the following object. So, the purpose of sedition is to attain the following. First, to prevent the promulgation or execution of any law or the holding of any popular election. For example, plebiscite, referendum, okay? Next, to prevent the national government or any provincial or municipal government or any public officer from exercising its or his function, or to prevent the execution of an administrative order. Okay? Next, to inflict any act of hate or revenge upon the person or property of any public officer or employee. Next, to commit for any political or social end any act of hate or revenge against private persons or any social classes. And then lastly, to despoil for any political or social end any person, municipality, or province or the national government of all its property or in any part thereof. Okay? So, these are the exclusive acts of sedition class. Okay? These are just matters of reading. So, when you say tumultuous, if caused by more than 3 persons who are armed or provided with the means of violence. So, the purpose of this crime is not the overthrowing of the government, but the violation of the public peace. Okay? So, this is a problem of peace and order class. So, under RA 8294, sedition absorbs the use of unlicensed firearms as an element thereof. Hence, it is not an aggravating circumstance, and the offender can no longer be prosecuted for illegal possession of firearms. Okay, so the perpetrator, if he is carrying illegal firearms, and then he commits sedition, then the crime of or the violation of the special law of firearm law is absorbed in the crime of sedition. Okay? So these are just matters of reading class. Okay. So under Article 140, these are persons liable for sedition, the leader of the sedition, and then other persons participating in the sedition. Under Article 141 is conspiracy to commit sedition. Okay? So there is meeting of minds. Article 142, inciting to sedition. Okay? Once again, you incite or you support. Okay? These are just, there are modes in the commission of this crime class. First, inciting others to accomplishment of any of the acts which constitute sedition by means of speeches, proclamation, writings, emblems, and etc. Okay? Like showing support, you bring signages, okay? And then, second mode is uttering seditious words or speeches which tend to disturb public peace, okay? And then lastly, writing, publishing, or circulating scurrilous libels against the government or any of the duly constituted authorities thereof which tend to disturb public peace. Okay? So these are just matters of reading class. I will leave this up to you. Okay?